Good morning, Ms. Chesiwe.
Good morning, CJ.
Are you well?
Yes, I am well.
Are you relaxed?
I am trying my best to be relaxed.
All right, I understand. Where did you study?
I studied my first degree at Vista University, and then the second degree at Free State University.
Yes. And where did you practice law and for how many years? Just take us through that as quickly as you can. What have you been doing in the practice of the law and where, before we get to the acting stints in the High Court?
When I completed my degree, I registered my articles with the law firm of Besaid & Notes Attorneys, and I articled there. And
If you could bring the mic closer so that everybody can hear you.
Okay, thank you. When I completed my law degree, I registered my articleship with the law firm of Besaid & Notes Attorneys. I stayed at that law firm and remained on as a PA at the same law firm. From 2002 until 2007, I was at that same law firm. And then 2008, I left the law firm and then joined the Family Advocate's Office.
2007? Yes.
From 2002, where I did my articles, until 2007.
Yes. And are you still with the Family Advocate?
No, I resigned to 2015 December.
Yes.
So by the time January I availed myself for acting, I had left the office of the Family Advocate.
I beg your pardon, from 2015, where have you been employed? I couldn't make it out.
From 2008 until, after I left the law practice.
After the Family Advocate, where did you go?
I immediately went into acting.
I beg your pardon?
I immediately went into acting at the High Court.
From 2015?
2016.
2016, yeah. Was it May?
January, in January, when I started acting. I finished at the law firm, at the Family Advocate's Office, 2015 December.
Yes.
Then 2016 January. In January, that's when I started acting at the High Court.
Are you still acting?
I'm still acting as we speak, CJ.
Yes. Very well. How did you find your acting instinct? Was it a serious challenge or was it not too bad to acclimatize from where you have been to the High Court life?
When I started acting, it was quite a serious challenge because it was something new, something that I haven't done before. But as you have your senior judges around you to guide you, to take you through it, it became more manageable, more coping, and the challenge was I was up to the challenge. I was able to manage with the work, and I found it quite interesting, and I enjoyed it.
And what is the longest period you've kept a judgment reserved for?
I try to write my judgments as soon as I have heard the matter, and at least I try by my best that before end of term, I must finalize the judgment.
Well, let me just, in terms of months, what is the longest period you've kept a judgment reserved for?
In terms of months, I would say about 3 months.
But never beyond 6 months?
Not what I can think of, except one matter that I did in Pretoria High Court, where the court file, I don't know what should I say, it got lost, but could be found nowhere. So I had to make arrangements to get a duplicate file from the plaintiff's attorneys. And by the time they sent me this file, I was already back in Bloemfontein. That was in June. So then they couriered the file to me, a duplicate file, which I had arranged with the attorneys to send to me. But as soon as I got the duplicate file, I wrote my judgment and sent it back.
Yes. Thank you. Judge President?
Thank you, CJ. Ms. Chesio, good morning.
Good morning, JP.
How are you?
I'm good, and how are you?
I'm good, thank you. You've been here before, haven't you?
I have been here before.
I am not going to ask you the questions that I asked last time because the transcript is available, and I believe it's part of the package that has been provided to every commissioner here. I do know, however, that since your last interview, you have acted again in our division and in Gauteng, is that correct?
It's correct, JP. I acted in North and South Gauteng.
And for how long did you act in Gauteng?
In North and South Gauteng, I acted for 8 weeks.
For 8 weeks.
Yes.
And how did you find the experience as compared to our court?
I must say, coming from a small division of the Free State and going to a big division like the Gauteng, North and South, kind of a legal culture shock for me when I arrived. And for example, when I arrived the first day, I was given my kind of like a trolley full of files. And I naively asked, is this for the whole week or 2 weeks? And I was told, it's reading is today, tomorrow you are in court. Okay, I dived in and I started swimming. I found it quite challenging. It was a very, very exciting challenge, and I enjoyed it. And the nice part is the judges in that court, both North and South, you could approach them anytime for guidance, for assistance. If you stuck somewhere, they were always willing to help. But I must say it was quite a great, exciting challenge.
Would you say you coped with the work that was allocated to you by the judge president there?
Yeah, I definitely cope with the work. I definitely cope with the work because now, fortunately, the Free State Division gave me a foundation. And that foundation was such that I was able to cope and manage my cases that were allocated to me. Kind of in a way, the North and South Gauteng actually put more concrete on my foundation that I have from the Free State. It was quite a challenge that I was totally able to cope with.
Thank you, CJ.
Thank you very much, Judge President. MEC Mashinini.
Very much, Chief Justice. Morning, Ma'am Chesio.
Good morning.
How are you?
I'm good, and how are you?
Thank you very much. I just want to take from the last question that was raised to you. You acted for 8 weeks in Gauteng.
Gauteng, yes.
Yes. And you indicated that you have got quite necessary experience. Would you say that you are ready to become a judge?
I would definitely say I'm ready to do that. I'm ready to become a judge because the exposure I got from both divisions, Free State and North and South Gauteng, have mentored, trained, assisted, guided me well to be ready to become a judge.
Let me just take you to one of the cases that I think you handled. The case of Felix Nkuna and the state. Can you talk more about that?
Nkundla?
Yeah. Of Welkom.
Or the criminal case of Welkom?
Yes.
I'm trying to recall it. If MEC can just give me some clues on that one.
The one of the car. You don't remember that one?
I don't remember.
Let me leave that one. Let me take you to Moshe John Mbele. You know the case of Moshe John Mbele versus the state?
Yes, that one.
Of the mental
yeah, I did that one
capacity.
recently.
What happened there?
That one there, it was a child who was 13 years and was raped by somebody who was about 20-something years, and the child was mentally impaired. And in that case, the appellant had applied to request that the judgment, the sentence be reduced as it was harsh, and he was only 21 years. So in that case, looking at the compelling and substantial circumstances, that's where I reduced the sentence to, I think it was 15 years.
The magistrate gave a life sentence. You changed it to 15 years. Can you talk on that one?
Yeah, I was looking at the issue that he was 21 years old. He was still a young man, and there was possibilities that he could be rehabilitated given a chance. So life in that one was quite harsh for him, for a young boy of 21 years old.
But you didn't take into consideration that this is a rape case of a mentally retarded person, and he was given by the magistrate life sentence. You change it to 15 years.
Yeah, in my view at the time, like I say, MC, it was more looking into the fact that even if you give us, if a sentence is given, it's a deterrence kind of measure, where.
In view of the rain, if you could speak harder.
All right. In that matter, it's a matter of looking at the same time that when a person has been sentenced, you are not supposed to punish them so severely that you don't give them a chance of rehabilitation. You at the same time looking at the
I'm sure you can do better than that. The rain is disturbing us, so
Can I go louder?
almost as loud as I do.
Okay, CJ, I will do that.
Okay.
In that matter, I was more looking at the fact that he's a young man and he has chances of rehabilitation. And for the fact that when one looks at sentencing a person, it's a deterrence to prevent that such offenses happen again. So in that case, I was looking more at balancing the offense with the sentence for him being a young man who needs to be given another chance to rehabilitate.
Okay. Thank you, Chief Justice. I won't pursue this particular point any further. The matter that I was trying to establish was that here is the magistrate giving a severe penalty so that a message must be sent to a person, and then that judgment is changed into 15 years. When a person has basically raped a mentally retarded person. I failed to get grips into that. Thank you, Chief Justice.
Thank you, MEC. Minister?
Ms. Chesiwe, I just wanted to clarify one thing quickly. You said you started acting in 2016 January.
Yes, Minister.
There seems to be a judgment of 2012 which is reported. In which capacity was involved? What's the name? State versus BM. Does it relate to you in any way?
The one that was reported, it was a matter that we were two judges and I wrote the judgment.
Is this a 2012 matter?
2012, yeah. I was also, in 2012, I acted for one term.
So you actually did act in
2012, yes.
You didn't necessarily start last year to act.
Oh, no, Minister, the fact that the continuous acting started in 2016. 2012, I acted for one term and then I stopped. But then 2016, I came back again.
I see. And you said that you served in the State Attorney's Office before you joined the Family
Advocate's Office. I worked in.
For how long were you in the State Attorney's Office?
In the Family Advocate's Office. Not the State Attorney's Office, the Family Advocate. Prior
to Family Advocate, you practiced as an attorney?
I was still an attorney, but in the office, when you are working there, you are designated as part of the Family Advocates. But I was still attorney because I did not remove myself from the role of attorneys then.
No, that's fine. I just wanted to get a sense of the sequence of your career trajectory. The question I wanted to check with you, maybe let me start with a follow-up on the question by the MEC. I am not sure whether punishment should not rather be commensurate to the severity of a crime, taking into account all circumstances involved, rather than to say that a person, because they were still young when they committed a crime, that of itself justifies a more lenient sentence. I'm trying to understand the rationale of that, like the MEC, because the difficulty I have with this is this. As the minister responsible for the correction system in South Africa, I can tell you now that the majority of violent crime inmates are young. Over 60% are young people. And there is this phenomenon of the association with violent crime and youthfulness, issues of drugs and other factors. Don't you think that it is precisely the reason why you need to send a stronger message to people who commit gruesome offenses, that in fact the mere fact that they're young should not be to their advantage when it comes to the penal system? And wouldn't that actually give us at corrections more time to actually implement corrective and rehabilitation programs, including skilling, so that when they emerge on the other side, they have had sufficient time to actually have their, offending behavior effectively corrected? I'm just trying to understand where this notion, is it coming from legislation? Is it coming from the common law? Where is that concept that if you are young, by virtue of age, regardless of the severity and gruesome nature of your offense, you should necessarily receive leniency from the justice system?
Minister, if I may say, it's not as if it's by reducing the sentence of a youthful person, you're moving away from the legislation applicable in that case. It's a matter of, if you look at that time, when you look at the substantial and compelling circumstances of the person, it makes you determine that the sentence can be reduced in order to accommodate.
Perhaps let me put my question differently. My apologies, Chief Justice, to pursue this point in this manner. Where is the victim in all of this? Because I seem to hear a lot about reaching out to the offender and accommodating the offender, taking into account, as you put it yourself, their youthfulness. Isn't the starting point supposed to be the impact of the crime on the victim before we talk of anybody else?
It does, Minister. For that purposes, in most cases, that's why the victim impact report is requested, to see the impact of the offense on the victim. So even if we look at the accused person, the victim is also taken into consideration.
But I haven't heard that sense so far in your motivation for why the reduction of sentence was seen by yourself as the appropriate response to that situation. I'm just worried that it seems as if we get so preoccupied with trying to find ways of accommodating the circumstances of the perpetrator and paying, I wouldn't say lip service, but at least, paying less attention to the impact of the offense on the victim themselves. Would you disagree with me?
I would not disagree, Minister, because in most instances, victims' report requests are made to check at the impact of the crime on the victim. Although it might be that the balance is not well equal between the victim and the perpetrator, but the victim is taken into consideration with regard to the victim's impact report.
Yeah. And
in
just
this instance.
Finally, Chief Justice, I'm concerned about, if I look at the balance of your legal work experience. You've been an attorney all in all for about, is it 3-4 years?
If I count from Article 2 years of the articleship and from a date of admission, it will be another about 3-4 years.
And
in private practice.
the balance of your legal career was as a family advocate, apart from the acting stints.
Yes, Minister.
And that's for how long?
In the Family Advocate's Office, plus minus a period of about 8 years.
You know, I must say, and that's why I want to put it to you, that I have this feeling that apart from the fact that you were given an opportunity to act, and it seems as if you did well, I am not convinced that you have allowed yourself sufficient opportunity to ground yourself in the practice of law sufficient for you to avail yourself at this stage. Would you disagree with me? And if you do, can you motivate why you disagree with me?
Minister, with regard to the issue of experience, I would say it shouldn't be a deterrence to give a person an opportunity. Quoting the CJ when he was briefing the LSA briefings, where he said, a person shouldn't be written off unless you have seen that person's potential, capacities, and opportunities to give that person a chance. Meaning that in a sentence where, in a situation where it is said the experience is lacking, if the person has the potential, has a spirit of a teachable spirit, person is prepared to work hard, the energy and the motivation, I believe an issue of lack of experience shouldn't be a deterrence to give that person a chance to prove themselves.
Thank you, Chief Justice.
Thank you, Minister. Colleagues, I know it's very early in the morning. Please, 2 questions unless it's strictly necessary, and please no preamble. Please. Commissioner Nyambi.
Thanks, SCJ. Morning,
Good
Ms.
morning,
Chisiwe.
Commissioner.
The last time you were here, you described the experience as nerve-wracking, and that may have resonated with Commissioner Modise to let it go as you struggled defining judicial accountability. And that was a few months ago. I'm sure this time you feel more comfortable indulging us on what your understanding of judicial accountability is.
Yes, Commissioner. With regard to the judicial accountability, being part of the separation of powers of the judiciary, the judiciary is accountable to the Constitution and to the people of South Africa. In most cases, when it comes to accountability, the judgments that are delivered must be delivered on time, must be done expeditiously. And with regard to that accountability, the OCG's office came up with the norms and standards for the judges to ensure that they are accountable. And with norms and standards, being part of accountability follows the case flow management of cases, where cases are monitored from point of entry to point of exit to ensure that cases are attended to. There is set certainty with regard to trials. There is set certainty with regard to postponement, and judgments are delivered on time. Cases are given enough time. Cases don't lie dormant in the system to prevent a setup where there is no accountability to the public or with regard to the Constitution. So in terms of accountability, the judges have to be accountable to the Constitution and to the people of South Africa by ensuring that their judgments are delivered on time and expeditiously.
Have you visited what happened the previous time you were here before coming today?
If I visited?
Have you bothered to check the previous interviews the last time you were here?
I checked my previous interviews, the transcripts.
Thank you, CJ.
Thank you very much,
Follow up,
Commissioner
CJ.
Nyambi. Yes, Commissioner Malema.
What do you mean you account to the Constitution? Isn't a Constitution a document like this? So how do you account to it? You account to a Constitution. What do you mean by that?
Oh, what I mean is that the Constitution gives the judiciary, in terms of Section 165, the judicial authority to do things to show that the judiciary is independent, it's impartial, it's accessible, and the judges must be the guardian of the Constitution, respect the Constitution, and protect it at all times.
Commissioner Norman?
Thank you, Chief Justice. Good morning.
Good morning, ma'am.
Acting Judge Chesiwe. I just want to direct you to the reserve judgments that are listed in paragraph 9.5 of your application at page 11.
Let me just look at it. Paragraph 9.
Yeah, 9.5.
Yes,
What is the status of those judgments now?
they've all been handed down.
When were they handed down?
I don't recall the date of Gianni and Gule, but the one that I explained earlier on, the Amos one, that when I said the file was lost, was handed down sometime in August. But the other two ones were handed down earlier on.
Yes, but are they?
I think in June, because in July I was doing, I was in North Gauteng doing a apartheid matter during recess.
Yeah, okay, maybe my first question should have been, are they from the Free State Division
No.
or are they from Gauteng?
Gauteng,
All of
Gauteng
them?
division, all of them.
Okay, but they've all been
They've
handed
all
down
been
now.
handed down.
Okay. How have you found your experience as a family advocate, because you've been there for 8 years? How have you related that experience to what you are currently doing now in the High Court and the work that has been allocated to you? Have you found that experience to be of value to you?
Yeah, I found it to be of value to me because when you look at the High Court is upper guardian of all minor children. And the Constitution, Section 28, guarantees all children's interest. And the Children's Act as well guarantees the minor children's interest. So when working in the High Court, I could apply what I had gone through in the Family Advocate's Office with regard to the minor child's best interest in the High Court, taking in mind that the High Court is the upper guardian of all minor children. So in that way, I could bring together that experience into the High Court space.
Thank you, Chief Justice.
Thank you, Commissioner Norman. Commissioner Stock?
Thank you very much, CJ. Good morning, Ms. Chesiwe.
Good morning, Commissioner.
Yes. Since your last interview and then your interview today that you are appearing before us as the Commission, I just want to find out from you what has been any significant improvement from your side, from the last interview and now.
From the last interview to now, I would say, because I continued acting, I feel I've gradually matured especially with regard to writing my judgments. I've gained more experience to know how to go about writing them. And I've gained even more better understanding how to handle the workload and manage with the workload and cope with the workload.
Okay. And then lastly, why do you think that you are ready to be appointed as a judge?
I believe I'm ready to be appointed because I have been acting for a period of time now, and my experience with acting in different divisions has taught me coping skills, managing skills, being able to handle the workload, and being able to regard the work as a very serious work that needs your 100% attention. So as far as I'm concerned, at this stage, I believe I'm confident enough now to face the challenge of being appointed as a judge.
Thank you, CJ.
Thank you very much, Commissioner Stock. Judge President Hlophe.
Thank you, Chief Justice. I have two questions for you. The first relates to skewed briefing patterns. There is a perception out there that black practitioners, particularly African women, do not get good work which prepares them to take their rightful place on the bench. were this commission to appoint you for a permanent appointment, do you believe that the judiciary should be actively involved in terms of ensuring that the briefing patterns are not skewed? In other words, that the playing field is level?
I believe so, Commissioner Hlophe, for the mere fact that, from my perspective as a woman, staying longer in private practice ends up not having enough briefings. You don't have much work that you receive. In fact, most of the work will be your divorces, maintenance, and things like those. So it will be quite an important thing if the judiciary can get involved, where briefing patterns are shared equally with women in private practice to make women stay there. Because in most cases, what happens, as a woman, you leave private practice, you join government for purposes of stability of income, because there's no work coming your way. So you go to a position where you are in a comfortable position, where you are stable in the profession that you will be, because briefing is quite skewed when it comes to private practice for women.
Secondly, Chief Justice, as a black woman, have you experienced sexism and racism? And have you experienced personally sexism and racism? And what can be done by the judiciary to address this, particularly sexism and racism in the profession and on the bench?
In the profession itself and private practice level, yes, sexism that I've experienced. But in the bench, I've not experienced any, because we in the bench, we treat it as equal. Even if you are acting, you are treated as equal. And how that can be done is to ensure that systems are in place to monitor, whether it is through the Law Society or through the different bar councils, to ensure that the different bodies comply with those monitoring tools to ensure that the sexism or racism doesn't happen around law firms or bar councils where the females are involved. Because even if you're at the bar council, you'll still get the small briefings, which are not major briefings for you to go to court. Like I said, you'll get your divorces, you'll get your maintenance, you'll get your Rule 43s. You don't get those major corporate briefings. And that's what I'm saying, in the end, you end up moving away from private practice and move into government position for purposes of, it's kind of like, I won't win the situation.
Thank you, Chief Justice. No.
Thank you, Judge President Hlophe. Commissioner Nkosi Thomas.
Thank you, Chief Justice. Good morning.
Good morning, ma'am.
Ms. Chesiwe. On page 14 of the questionnaire, if I may direct your attention there, please. Towards the foot of the page,
yes,
there's a question there that says, that asks if there are any other relevant matters, or if there's any relevant matter that you wish to bring to the attention of the Commission. And you state that you conducted a judicial inspection. Would you like to tell us more about that, please?
Yes, Commissioner. What happened here, I was on circuit court in Kroonstad, and I was requested by our JP to go and conduct a prison inspection at the Kroonstad Correctional Services, which I did.
Yes.
I did the female section, the children's section, the juveniles, and the male section. What I discovered, the female section, it's not crowded. The numbers are okay, because most of the females, some of them are with their children. And then the male section, it's totally overcrowded. And never mind the overcrowding, the way the place looks, it's like it's not maintained, it's not clean, it's just conditions that are not nice for a human being to stay in. But most of the time, of the prison wardens are doing their best to make the stay of the prisoners as comfortable as possible. And then with regard to the female section, the children are kept there within that same environment of the parents, of the mother, where the child will be released about at 18 months or 2 years out of prison to the family. The mother remains behind. And what I discovered, that those children are quite traumatized, because just approaching the child cries hysterically because the child doesn't know people from outside. So the concern I also had was, when this child gets released to a family member who he has not seen in that time, it causes quite a lot of trauma. But the prison official said it's a problem that they are sitting with because the family members don't want to come and visit or to take care of the child because it's kind of like a burden for them to take a child if the mother is still in prison. But the issue of overcrowding is there. I observed it, and it's quite a serious problem.
Yes, would you say that that inspection has empowered you for purposes of discharging your judicial functions were you to be appointed?
Yes, it has done that, and I forgot to mention that I also did another inspection with Judge van der Westhuizen at the Grootvlei prison. But in this case, I didn't write a report because he was leading the investigation. We're just working with him. But it has empowered me. It made me realize actually how serious is the conditions in prisons.
Thank you, Ms. Chesiwe, and thank you, Chief Justice.
Thank you, Advocate Ndwesi Thomas. Commissioner Nokesi.
Thank you, Chief Justice. In the questionnaire, page 3. Page 3.
Page 3.
You indicate that in 1998 to 2002, you were a member of the African National Congress, and that membership lapsed. And then 2006 to 2009, you took membership of the Democratic Alliance, and that membership lapsed as well. Do you belong to any political organization now?
Currently, I don't belong to any political parties because I realized that if you want to serve the bench, you cannot be a member to any political party. So currently, I'm apolitical.
Yeah, okay. And last time, that's the last question. Last time if you remember, we debated about your understanding of the difference between motion and trials. Do you understand now the distinction
yes,
between
now,
those two?
Yes.
At least you have picked up on
I've
that.
picked up on that.
Thank you very much.
Thank you.
Thank you. Thank you, Commissioner Nokesi. Professor Mthekga.
Ms. Chesiwe, I visited Sun City Correctional Center with a group of men. We visited a ward where mothers were staying with their children. And when we entered as men, the children cried and ran away from all of us.
It's exactly like that.
Now, do you think that children should be kept in prison with their mothers? If so, what would be the impact of such detention when these kids grow up as women who must be married, but they run away from men?
Commissioner Mthekga, like I've said, it also traumatizes me when I was there because I am a woman for that matter, and I wanted to pick up the child. The child was hysterical. And it made me realize that the impact this child has, or these children have when they're in prison with their mothers, it's quite a serious impact. We don't know how deep it goes when these children grow up. I even made a recommendation to request that, although it's issues of budget, if the children, when they are in prison, can be put in a creche outside the prison, where they meet other kids, other mentors in the creche, meaning that the child will be exposed to other people, not only to prison people around them. That the trauma of seeing new people will not be as traumatic for the poor child. It is quite a serious thing that, Commissioner Mthekga, that I also had an issue about it.
Do you think a budget should really take precedence over the future of these children? Because there's a lot of wastages outside. Shouldn't we prioritize the children other than the budget?
It should actually be done like that. I even recommended that the Department of Social Development should get involved, where they either get a family member who comes and visits the child on various occasions, that the child bonds with somebody from outside. Social development gets involved on the basis that they must attempt to see how they can make things easier to get the child out of the system, where the child will be with family members or in a place where it can be cared for outside the prison. The whole thing is about children should actually not be in prison.
Thank you, Prof. Commissioner Schmidt.
Thank you, Chief Justice. On the issue of the briefing patterns, in your acting periods in both Gauteng as well as the Free State, do you know and can you say who the state attorney the briefing patterns of the State Attorney's Office?
Truly speaking, those who appeared before me were senior counsel. If I need to say, it was white male senior counsels that appeared before me, meaning the briefing patterns of the state attorney was briefed to male senior counsels.
Which is concerning from the point of fact that the State Attorney's Office is exactly what it is. It represents the state.
It represents the state, but it would be fair if the briefings are given to everybody who's prepared to appear for the state.
I agree with that. Thank you, Chief Justice.
Many thanks, Commissioner Schmidt. Ms. Chesiwe, thank you very much for coming. You're excused, ma'am.
Thank you, Commissioner, and thank you to the Commission panel.